Hi everyone, it's Mark and welcome back to our video newsletter. In this video I want to talk to you about involuntary placement and how you can revoke your consent to be at a facility. So there are two ways that you can be admitted into a Baker Act facility. Involuntarily, in other words, against your will, and I've talked about how that can happen in other videos, and voluntarily. In other words, you went there and agreed to stay, even if you didn't realize you were going to stay, and in most cases the person doesn't realize they're going to agree to stay because they don't even know what the paperwork is that they've just signed, okay, where they've said, I'm agreeing to stay. But what happens is typically someone goes to a facility, either they've just, Googled facility or Baker Act facility or how do I get help for anxiety or depression or things of that nature, or their doctors told them to go to a particular facility, and they've gone there seeking help. Okay, they're having issues with anxiety and depression, and Lord knows, in the current sort of COVID-19 environment we're living in, people are having these types of issues. I mean, aren't we all having some type of issue when it comes to this? Because frankly, we've just been separated from families and loved ones and had to deal with the stress of this. Okay, but people are going to facilities and they're saying, look, I need help, and what the facility says, well, sign here. We'll get you help. And what they don't realize is they've just agreed to stay. They've just agreed to stay. And now they're trying to get out. Okay, they figure out within sort of a very short period of time, perhaps a couple hours, when they say, okay, I feel better now, can I go home? And the facility says, you're not going anywhere. We're going to keep you. So in this video, I want to talk to you about how you can revoke consent and who can revoke it and what can happen if you even try to revoke consent. So basically, once you go there and you agree to stay voluntarily, if you no longer meet criteria, separate apart from whether you ask to be released, they're not supposed to keep you. Let's say you go there and you say, listen, I'm having issues with anxiety and depression, but you don't meet Baker Act criteria, they're not supposed to keep you. Okay, if you don't present as a danger to yourself or somebody else, you're supposed to be released. Remember, the Baker Act facility is not designed to treat people. Okay, it's designed for emergency stabilization only. This statute, Chapter 394, the Baker Act statute, this is an emergency stabilization statute. It's not a treatment statute. Okay, but what happens is that when people go to a Baker Act facility and they ask for help, they want treatment, the facility takes it as an opportunity to shoehorn them into the four corners of the Baker Act statute, bill their insurance, bill the family, and now they are stuck in a facility. So they say, well, listen, I want to leave. Okay, they tell a staff member, I want to leave. The facility says, no, you can't do that. You got to sign the paperwork. You got to revoke consent. It has to be in writing. That's simply not true. It doesn't have to be in writing. In fact, if the loved one is in a facility and they tell a staff member they want to leave, it's supposed to be documented in their clinical file. They're supposed to be able to revoke their consent. A family member can revoke their consent. I, as the lawyer, can revoke the consent. Okay, and that's the way it's supposed to be to work. Okay, and so once consent's revoked, the facility is supposed to release you within 24 hours of the request to be released. But here's a sort of wrinkle in this thing, okay? And I can tell you, this statute is full of wrinkles, okay? And I'm going to read you this section because I think it's really important for you to understand. The 24-hour period may be extended by a treatment facility when necessary for adequate discharge planning, but shall not exceed 3 days exclusive of weekends and holidays. What does that mean? It means they get at least another 3 days for, quote, discharge planning, okay? And if the 3 days or the last day of the third day falls on a weekend or a holiday, guess what? They get those too. They get those too, okay? And if you do revoke consent, okay, and the facility says, okay, they're revoking consent, the facility can then go to court and petition the court to keep you, potentially up to 6 months, okay? So while I can go to court, they can go to court too. And as I've shared on many other videos, these cases are typically won or lost by who gets to the courthouse first. It's a race to the courthouse, and I like to win that race. I don't like to lose that race. Okay, the facility needs to know they've been caught with their hand in the cookie jar. They need to know that they have violated the person's rights under the Baker Act statute, and that they've been caught. Okay, because if they don't, if they're not placed on notice, if nobody informs them that they've been caught, they're just going to keep doing it because there's no oversight and nobody is watching them. Okay, so with that said, this was a great question that was asked of me, and ultimately we got a good result for the family. But time is of the essence with these Baker Act cases. We got to move fast. So with that said, take care, be well, stay safe. If you have a question, send it to me, email it to me, send it through the website, call me. I don't charge for a consult. Take care of yourselves, be safe, and be well.